Welcome back. It's Philip Bickle at Legal Tyranny. It's July 14th, 2021. We're going to continue on my reply brief for my traffic infraction appeal, and we're in the arguments section in section B. Let's get started. He repeatedly admits that the offenses on appeal are civil traffic infractions and not criminal offenses. From the Appellee's answering brief, page 9. The violations alleged were not criminal offenses but civil traffic infractions. Traffic infraction means all violations of statutes, ordinances, or rules relating to traffic movement and control, including parking, standing, equipment, pedestrian offenses, for which the prescribed penalties do not include imprisonment, and that are not otherwise specifically excluded from coverage of this chapter. Okay, any of you guys that have been researching this sort of stuff for a while already know that in very clearly laid out in other states, including California, and they may have changed it at this point because of people like me and other pro per litigants that study this. This very explicitly is a commercial activity, parking. So, half the words that you guys go and use, I mean, there are words that you guys will use, and you're not even talking about legal issues, but they're actually legal terms that have trickled out into our common language, and people just don't even, like the word person. That word did not exist outside of law, and you have people saying, corporations aren't persons. I saw this on somebody on Facebook that I was associated with had, written up a big rant about corporations and how they're not, persons and blah, blah, blah. And I said, actually, you got it all wrong. Corporations are persons. It's people that aren't persons. Persons, I had to lay that whole thing out for them. But some of you have already been researching this stuff for a while, and you're familiar with that, and I wanted to point this out because this is Hawaii code, and I don't recall off the top of my head if they have park or parking defined or anything relating to this where it's easily discernible that it's a commerce-related thing. However, these are all commerce equipment. Any of you familiar with his name? Rich Iverson. I think it's Iverson Parks or Parks Iverson. His work goes over how in California they've got the equipment versus commercial, or equipment, which is commercial goods versus consumer goods. And I saw somebody comment on one of these channels how, oh, that's funny, maybe we can go, ride the fridge someplace, treating the refrigerator a consumer good as if, I don't know. I mean, they haven't studied the law long enough to comprehend what's going on here. They don't understand these definitions and how there are so many words that even they use. They don't realize they're legal terms of art, and they don't actually have a full comprehension of what the terms mean, and many times they use them improperly. When I use the word traffic, if I use it, and I'm not talking about any of this sort of stuff, this legal stuff, then I'm usually talking about volume, because that's how most people use the word traffic, volume. They don't use it and realize that traffic is supposed to be a commerce-only term describing the activity of automobiles in commerce. They're on the road, they're in commerce, that's traffic. Okay, so that was just something I needed to point out because, these issues, movement and traffic control, all these things are commercial. Now that's a separate issue to be argued, though. And I don't go into arguing a lot of those issues here because that just isn't anything that these people are willing to really touch on. Okay, so Officer Davies at no point in time offered any probable cause to justify initiating an arrest and seizure of myself and the Ford F-150. The appellee offered no evidence of probable cause that a crime had occurred or was occurring based on evidence presented by Officer Davies Officer Davies performed the arrest without a warrant, which is prescribed by the United States Constitution, Fourth Amendment, to wit, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Hawaii State Constitution includes provisions against these actions. Section 7. Section 7 is essentially a restatement of the Fourth Amendment, except this is in the Hawaii State Constitution. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, invasions of privacy shall not be violated. Blah, blah, blah. Pretty much the same thing. Read this yourself. It's practically the same. It's functionally equivalent. The Hawaii revised statutes on warrantless arrest explicitly prohibit the use of warrantless arrest for anything but criminal behavior. This is killer right here. I think the first time they read this, they realized they had a hot potato on their hands, but they decided to keep trying to squeeze me, get me to give in. I don't know what the deal was with that. Again, I may be on a list or something after suing that judge. Okay, by police officer without warrant. A police officer or other officer of justice may, without warrant, arrest and detain for examination any person when the officer has probable cause to believe that such a person has committed any offense, whether in the officer's presence or otherwise. I want to point out a couple facts about this particular statute and this Section A. The way that they've worded this, they make it sound, to somebody who doesn't study this well or comprehend the material well, they make it sound that an officer can arrest and detain for examination any person for committing any offense. Probable cause for any offense. Well, an offense, if you go and you look at the criminal code, I use, even though I'm in Hawaii, I reference California frequently. Again, they all have functionally equivalent codes to carry out certain things, and that does include the classification of offenses. So you can look at offense as being at the top, and then it divides into two separate categories, criminal and civil. Under civil, you have things called infractions, or they're called violations. Depends on what state you're in, or they may use them interchangeably. Under the criminal side, you have what they've broken into different classifications, and it's created, I don't know, just all this chaos with, what they're able to do in terms of what is a crime or what isn't a crime and how severely people are punished. But they've broken it into like felonies, different classes, and misdemeanors, and petty misdemeanors. But we know that this breaks down into other categories, and B deals with that, because you're not allowed to make an arrest over any sort of civil infractions or violations. And they tell the officer that here, right in this section. For purposes of this section, a police officer has probable cause to make an arrest when the facts and circumstances within the officer's knowledge and of which the officer has reasonably trustworthy information are sufficient in themselves to warrant a person of reasonable caution in the belief that a crime has been or is being committed. Okay? Crime. Not an infraction, not a violation. Crime. Two different classes. So, put this into thought now. Every single speeding ticket that a officer stops someone for, where they're not going over into what would be considered a criminal offense, which I believe is upwards of 30 miles per hour or over. And that's what they did to me in my most recent case, where I got the no driver's license, what was it? No driver's license, and shoot, there was one other thing. I got them to drop it because they couldn't prosecute me. The law had been suspended at that point in time, and this is heavy right here. We'll talk about this in another set of videos. But during the whole COVID issue, these unlawful governor mandates, they're not allowed to create law. Cops are not allowed to enforce anything that they're mandating. They're not allowed to. Only the legislature can make law. In the emergency acts that all state legislatures have created, the bar uniformly made it so that the mandates allegedly are given force of action. That violates the separation of powers. A governor cannot make law. He's in the executive branch, the legislative is the only one allowed to make law. Just like in my other videos where you see a prosecutor is the only one that's got the license to practice law, and he's in the executive branch, so he can initiate prosecution. A court clerk is in a judiciary branch, and they're just there to process things, but they are not allowed to take a ticket and create a case out of that. That's the initiation of prosecution between a clerk or the cop. One of them, somebody created the case, and for our purposes, the prosecutor is alleging the cop created the case. However, we've already seen the cop can't do that, but we also know that the clerk should have never, opened up a case and created hearings. They didn't have the documents that they were required to have by the authorized personnel that were required to follow them. So this is a huge issue. Every single speeding ticket where somebody's doing, 20 miles per hour under, anything in a state that doesn't constitute a criminal speeding offense, which would be reckless, they cannot stop you for. Now, when I got stopped, the guy alleged, I'll have to check my recording. I think he said he claimed I was doing 82. It was 55 in that section. I know I wasn't speeding. I told him I wasn't speeding. And like I said, I actually wonder if they were paying attention to the trips that I had to make over to the court, because I had to be at the court that day. And they knew that I was on this side of the island, the other side, and there's only one reasonable short route, although I've taken other routes over, but that's the only short route over. So, and they know they've identified, the automobile that I was using and the dates that I was there, and all it takes is one disgruntled cop to decide he's got to pull you over. Well, they dropped the other charges. That one I could have fought, but I was just too beat to fight it, and I still have the opportunity to get the judgment voided because they never charged me. And that's my most recent case. If you look it up on Hawaii Ikakua and do a search on Philip Bickle for the name, and you'll see the cases 2020, and the no driver's license got dismissed, whereas they actually convicted. I haven't even completed counting the total number, but they convicted a ton of people for no driver's license during a period where that law was just allegedly suspended. So on the one hand, they tell you it's suspended, you don't have to get new inspection stickers and stuff like that during the time, but they don't tell you at the same time that the entire traffic code, highway code, was suspended. Section 286, or Chapter 286. They don't tell you absolutely nothing could be prosecuted from that during that time, but they prosecuted it. You had public defenders handing people over, and you had prosecutors prosecuting people, and you had judges convicting them. All three. All three of them, and are all members of the Bar Association, with the prosecutor and public defender being active and a judge being inactive members. So let's keep going. At no point during the trial or any of the proceedings did the appellee provide evidence that the arresting officer had any proof, probable cause, or reasonable suspicion that I had committed or was committing a crime. These issues were raised at trial. As was stated in the first answer to traffic infraction, if the legislature had intended that officers be allowed to make warrantless arrests for non-criminal behavior, they would not have included Section HRS 803-5B, as it clearly exempts non-criminal behavior. So they can't go around. This is the same thing as going and somebody decides to sue somebody else for damages on something. And, like, the equivalent would be a cop going and arresting the person that is being sued. And, I don't know, maybe they spend a couple nights in jail, or a night, whatever. And then they get out, and then they got to deal with everything as they would typically in court. But that's like the equivalent with how they're carrying things out with people for, say, speeding or any other infraction-based thing. No expired inspection sticker, no license plate, brake light out, any of those things. They're not allowed to stop you at all. That stop is an arrest. The way it ought to be carried out by them is if they can get your plate, if you've got one, they look it up and they issue a citation for, tail light out or something, fix-it ticket, and you get it in the mail. That's how that should be done. But see, they don't get money. They don't get close to you. They don't get to interact. They don't get to see if you've got something else that they can nail you for by stopping you. That's why the courts are all in favor of you being stopped. If they can't stop you, they're not allowed the opportunity to do what they want to do, which is to dig deeper, and they need that opportunity. It's like a detective talking about a crime. You want to look at motive and opportunity. Well, motive, cops have to earn a living, right? So they can't go out day after day and not have any arrest or any citations written, especially with the way things are running now off of our debt-based currency. Everything is allegedly, in debt at this point. So they got to go out and they have to make numbers. They have to fill a quota, even though many places will say they have no quota, which means they have no limit. They'll just stop as many as they can. But, they've got the motive, so they want to be able to make those stops. Now, the opportunity comes with being able to stop you. They shouldn't be able to stop you over anything that's not criminal. The law says that. The courts are not going along with that anymore, though. It's anarchy in the courts, even at the higher levels. But by providing cops with that opportunity, they could see if somebody's got something on them. Maybe they don't like the person. Maybe they've got a chip on their shoulder that day. But they can engage in all sorts of behavior just by virtue of the fact that they've got you held at their mercy. You're on the side of the road, they got a gun, you better behave. In most cases, they're not violent against people, but they are thieving off of the people. If there are statutes, and those statutes say that the civilians aren't allowed to do certain things, and if they get caught doing them, they can be held liable for certain fines, then why the hell are cops not held to the same standard? If a cop is required to do certain things, and a statute lays that out, and I pointed this out in other videos, how they're not doing certain things, or they're doing things that they shouldn't be doing, and they aren't permitted by statute. Why don't they get fined? They're never going to get fined, because they're the money makers. They're bringing in money, and that money, in a case of a state like California, every single fine and fee has a fraction of it taken out and put into the county general fund for whatever county the incident occurred in. And then at the end of the month, there's two judicial funding retirement systems. Judge Retirement System 1 and Judge Retirement System 2. That's actually what they're named. You can see this in the statutory code. And in those codes, they take a fraction of the general county fund and put it into the judge's fund every month. So they're laundering, and they're laundering that money from the portions of those fees. And the California Constitution actually prohibits judges from getting any percentage of fines or fees. I can't even remember the sections. There's so much law. Oh my God. Yeah, there's just so much stuff. It's impossible to remember all this, but I feel like it's section 17 of something. But if anybody's in California and they want to look this up, go to the California Constitution and go to the section on judges and look through there. And it's a short paragraph, and it's like the last sentence of one of the paragraphs. And you could do a search on a keyword fine, and then if that doesn't pop anything up, do a search on the keyword fee, because it actually says fine or fee that they are not allowed to get. So in that state, they very clearly have the money laundering mechanism set up in the statutes. Over here in Hawaii, it's not as clear to me, but I'm sure they're doing the same thing. I mean, they make everything functionally equivalent, and if they've got one racket running in one state, they're going to have it running in another state too. Okay, we're going to wrap it up here. If you found the information informative and useful, please give the video a thumbs up. If you're not subscribed, please consider subscribing. And if you are subscribed, please hit the notification bell so you know when I have a new video posted. And as always, if you can copy and paste videos that specifically would help certain people, that helps me out, because this information isn't going to get out any other way. Thanks. Until next time.